Now, the leadership of the Joint Unions Action Committee of the Federal Capital Territory Administration and the Federal Capital Development Agency says the demands that led to the industrial action, which began on Monday, January, remain unresolved. The union insists that their members have fully complied with the strike directive and the action will continue until further notice. They also note that discussions held after the strike commenced have failed to yield any meaningful progress, adding that its grievances have been raised for several months prior to the action. The union has also confirmed its readiness to appear before the National Industrial Court on Monday, January the 26th, 2026, following reports of a legal action initiated by the Minister of the FCT, Nyesom Wike.
Agitating for our rights that have been trampled upon as workers, and the demands have not been met. We talked about our wage award arrears, which has not been paid. We talked about our pension, which has not been remitted to the pension fund administrators. We talked about our National Housing Fund. We talked about elongation of directors. We talked about intimidation of staff, that when somebody goes wrong, instead of them to use the civil service way of punishing or disciplinary action in line with the civil service rule, we didn't really know about it. We just started seeing papers flying everywhere and all, that we've been taken to the court by our minister. And hey, here we are. We've not received particularly a letter from somebody. We learned it's on the dailies and people took it out from the dailies. And later, early in the morning, we learned that some were pasted here, but we've not really gotten anything from them hand to hand. It was the one they pasted that we were able to see today. Definitely be in court on Monday. Our father has taken us to court and we're going to meet him in court. A stronger father, weaker children, we will meet in court.
I'm now being joined by Emmanuel Ogbeche, who's a journalist and public affairs analyst. Thank you for joining us, Emmanuel.
Thank you very much, Nathan.
Also joining us is Michael Amosun, a legal practitioner. He joins us virtually. Hello, Michael. You're muted. While we're waiting for Michael to sort himself out.
Hi.
Okay, fantastic.
Good evening, Nathan. Good here.
Good. Thank you for joining us. Let me start with you, Emmanuel. So this has happened. The union says we're going on strike. The FCT says you asked for 14 things, 10 have been taken care of. You don't need to go on strike. But the union insists, and the FCT goes to court.
Actually, it isn't moving for a thing. I did a head count of the demands. Actually, there are 22. And they were partially, implemented by the administration. But that isn't good enough because, for instance, let's take deduction for National Housing Fund. And the law says after deduction within 1 month, you're supposed to remit. And there's a penalty for that, and you do not remit. And we know that there is a severe housing shortage in Nigeria, about 16 million, according to government statistics. And you fail to remit what you've deducted. Now, let's give it to the minister. He's done quite considerably in the FCT. But in terms of the welfare of workers, it's been a consistent battle. Remember that FCT primary schools were on strike for 3 months.
FCT health workers are on strike right now.
FCT health workers are on strike. That means a full term, pupils in public schools could not go to school. That was lost. As we speak, teachers that were responsible for the marking of mock exams since last year haven't been paid. And mock exams are supposed to start next month. You understand? So there are a whole lot of issues, and it isn't even good enough to say, okay, we implemented some of your demands. Invite them back to the negotiating table.
Let's see if we can get Emmanuel to weigh in on the legal side. Emmanuel, the industrial court situation. I mean, we always find the leadership rushing to the industrial court to stop unions from going on strike. But what's the role of the industrial court when it comes to labor issues?
Good evening. Thank you very much for having me. Michael is the name.
Oh, yeah,
I
Michael,
think you called
sorry.
me
I called
Emmanuel.
you Emmanuel,
Yes,
sorry.
I get it. I get it. So, like you've rightly pointed out, the National Industrial Code has been empowered to take up any particular matter that concerns employment, labor, union, employer-employee relationship. So it's a normal thing if the government or the employee themselves go before the NICN to institute an action or restrain a particularly as it concerns employer-employee relationship. So one of the Constitution already gave that power to the NICN to actually address this particular matter. So it's a normal thing. This particular one too is before the court already. We expect that the court, because I'm very careful not to give any opinion on the outcome of what the court will do. Since before the court, we expect that the court is going to adjudicate on this,
Okay.
and then get back to the public on. We will know what the outcome of the matter is.
Should the leadership be more like waiting by the roadside, like in hiding, for the unions to complain or go on strike, and then jumping with the industrial court solution, so to speak? Shouldn't there be conversations?
I think there's the conversation. From what I don't know, but ordinarily there should be a conversation. Section 33 of the Act also says that there must be a board of inquiry. A board of inquiry can be set up by the minister so that it can look into the particular matter that is going on. So in this particular case already, I understand that the DSS I think one of the management is already talking to the GJUAC. So I think that's a good, because the law does not also say that a particular set of persons should be nominated or selected as being a member of the board of inquiry. So whichever the person is, so long as they're having a two-way conversation, then we are good to go.
Okay. Emmanuel, right now, the union has said, well, let's go and meet our father in court. But you said earlier about workers' welfare having been like a perennial situation, so to speak, in this administration. What do you think is the quickest solution that can?
Well, the quickest solution is for the administration, the minister, to diversify his attention, not only in terms of road construction, because basically that is where his strength lies. He must stay focused on the governance of the FCT, administering the FCT. At the moment, one imagines that he's distracted by what's happening in Rivers State, and throughout half of December, he wasn't in the FCT. That means files that were not treated probably were taken, by officials. That means you're incurring more expenses in terms of running the administration. So what the quickest way is, look at what the demands are and look at the ones that are feasible. For instance, the workers say 13-month wage allowance. You paid only 35,000, which is for 1 month. And they were demanding for 6 months wage allowance. You paid only once, and that's 35,000. That isn't good enough.
The other demand was extending the tenures of directors and who are supposed. And then we see that one of those people who's supposed to be retiring in a few days is already being appointed as an essay. It's
become a norm with the minister. Once you're retiring and you're in his good books, he appoints you as a senior special assistant. It happened with the director that was in charge of development control. It happened with the first, I think that was the acting head of service, that is serving as a senior special assistant. Now we have about 4 or 5 of such instances. And when you have a situation where political heads appoint 8 that are directorate equivalent, most times you forget about the core bureaucracy, the civil servants, and you begin to use this. It isn't good enough. There is a reason why there is a bureaucracy. And it is in your place as a minister to carry everybody along. And that isn't happening in this instance.
Michael, one word of advice to the minister, what would it be? And to the union?
Further consultation. I know that whatever is before the NICN, it does not include anything to impede or put their right to strike, because they are being granted the power to actually organize themselves and protest again. Go on strike against anything that's. So if there's anything I want to say to the minister further consultation. So long we've heard that there are consultations already. I think the better the consultation, the better the output at the end of the day. These people are not also violent. The people, from what I've seen the president speak about, the president of GUSC, she's speaking so calmly, and then I'm sure that the other members too are listening to us. I don't think really there's any cause for alarm. There should be further consultation, and so that this thing can be solved amicably.
Emmanuel, final word.
Well, I agree with Michael. He should come down from his high horse. We draw this matter from the industrial court. We know it is there for such instances, but reassure the workers that I'm twisting you. And whatever it is, we can sit as a family and address those issues.
Thank you so much. We've been speaking with Michael Amosun, a legal practitioner who joined us virtually. And in the studio, we had Emmanuel Ogbeche, a journalist and public affairs analyst. Thank you for coming.
Thank you very much.
We wish you guys well.